Court is in session. Good afternoon, everyone. I am the Magistrate Reginald Blackstone, presiding over this matter, bearing reference 2025 CM 036, the State of San Andreas versus George Jenkins, Richard Browne, Barry Lenkin, and Paul Richard. As there's not many people in attendance, the court will, however, go with the usual rules of the court before we shall proceed with the declaration of representation. Firstly, the parties are instructed to address the court and not each other. If one person is speaking, everyone else is silent. If the court is speaking, you are to stop speaking at once so that orders can be issued and directions given. Those people in the gallery, who appear to all be attorneys, most certainly do know the rules, that they should remain silent and respectful during these proceedings and should avoid making any disruptions, which would, of course, disrupt these proceedings. If counsel wish to raise anything for the court's attention, we would appreciate it if they could do so through trying to ensure as minimal disruptions as possible, unless it is during the questioning of a witness and it is for an objection, in which case that is most in order. The court has gone over the rules of this court. I believe that is quite reasonable. I think everyone can agree with those. We shall now move forward with the declaration of representation. Firstly, for the state, who do we have?
Jade Hellstern, first chair.
Yes, thank you very much. And then afterwards we'll proceed with the defense counsel.
Good evening, Your Honor. Stephen Armstrong with the Office of the Public Defender, first chair on behalf of the defense.
Second chair, Your Honor.
Outstanding. And if the three defendants, well, one is already risen. I hope your knees are all right, sir. Unfortunately, I struggle with arthritis myself, and I hope you're not suffering too much with having to be stood up, if that's all right. Could you all rise and please raise your voices to the heavens and please declare your names for the record?
Your Honor. Your Honor. Your Honor, right here.
Outstanding. I believe was there one that's missing? I believe we're missing Paul Richard. Is that correct, defense counsel? That
is correct, Your Honor. Mr. Richard is not in attendance tonight.
That's all right. Would you like us to rule in absentee on his behalf in light of he didn't complete the scheduler, which this court won't really hold it against him if he was unavailable to attend. So are you agreeable to move in absentia?
Yes, Your Honor, we are.
Outstanding. Okay, with representation declared, we shall firstly address the matters of the pre-trial diversion, which was submitted to the docket. This court is quite hesitant to approve a pre-trial diversion, as it was submitted really less than 24 hours prior to trial, which causes some concern for the court, particularly given this is a pre-trial diversion rather than a plea agreement or something of that nature, which realistically this could have been addressed a lot earlier. The court would like to inquire, when were these discussions held and when was an agreement struck? Either party can answer. Don't all scramble at once. Surely somebody knows roughly when these discussions began.
Your Honor, just give me one moment. I'm just trying to look at the specific timeline.
Your Honor, the talks of any kind of agreement started on March the 3rd.
March the 3rd, and we're currently on the 10th. Was this not brought why was this not brought to the court's attention prior to this point? Obviously, the 9th. We've already gone through a preliminary hearing. We've gone through the examination of evidence, objections to evidence, metabolizing the various affidavits which were submitted. To the court's understanding, everything was raring to go up until 24 hours ago. And particularly with a pre-trial diversion, and on the grounds it would appear that this being their clear records, why was this not done sooner?
Your Honor, the state brought several different options to the defense since the 3rd, and it was just yesterday morning, I think, after the stay was denied, that we came to an agreement.
my question would be, was there any stage where you were close to reaching an agreement? Because the issue that the court has at the moment is the fact that this matter appears prepared to go. There appears to be no reason why this can't proceed now. And realistically, this pretrial diversion is quite uncouth to submit at such a late stage. Why was this not brought to the court's attention? There were discussions happening before the 9th, when they've been going on since the 3rd.
Your Honor, if I may, the discussion in regards to the pretrial diversion started on Friday.
So the pretrial diversion was discussed on Friday, but there
Correct.
were discussions pertaining to potentially resolving this matter out of court.
Yes, Your Honor.
And was there any prospect that either party would approve it?
No, Your Honor.
There was not. So why have we got it now?
Because the previous discussion were about plea agreements and potentially changing of charges, which neither party could agree on in the end. The state reached out to us on Friday in regards to PTD. We immediately brought the attention to our clients, which had responded, I believe, a day later.
Right.
Yesterday we gave confirmation back to the state that the PTD is proceeding.
Understood. Now, how is it that a pretrial diversion has been given this matter? When was it brought to the prosecution's attention that these people had no criminal record?
Sorry, Your Honor, give me just a second.
Not a problem.
The prosecution had come to the idea of doing a pretrial diversion on the 7th upon talking with Bert, because we were having issues trying to get any kind of deals figured out.
That's not really what I asked. I asked, when was it made clear to you that they had no criminal record?
Yesterday, Your Honor.
Yesterday, Saturday?
Yes.
Or Sunday, sorry.
Sunday, sorry. Yes.
Sunday. And these discussions were begun on the 7th?
Between Bert and I, yes.
Right, okay. Are the parties prepared to proceed in this matter?
The defense would be, Your Honor.
And the prosecution?
Yes, Your Honor.
You would be prepared to proceed?
I would be, yes.
Right, I'm going to turn now to the point of the defendants here. What I don't want to do realistically is I don't want to put them in a precarious position where they have agreed on something and is assuming it is happening. The court is now admonishing counsel for this, because of course this should have been done a lot sooner. Notice should have been given to the court, so a lot of this could have been addressed. Bear in mind, scheduling is incredibly arduous upon the court. It is an incredibly difficult balance to strike, especially when you're trying to deal with multiple people, some of whom do not complete schedulers, and then afterwards sanctions have to be issued. If this was done sooner, $500 would not have been in sanctions, would not have been issued to 4 defendants here. The sanctions of which was more than if they would have been found guilty of the offense. This court does not want to proceed with this trial if, realistically, the defendants are being put in an awkward position. It appears the parties want to proceed with it. However, this court will stress now that as soon as there is a glimmer of discussions, it is notified to the courts. Because otherwise, matters like this happen, where 24 hours before trial we're notified, and then afterwards everything's all topsy-turvy and we don't know where we're stood. So we'll move on to the terms of the pretrial diversion. As these appear to be on the Department of Justice's letterhead, are these in quadruplicate or are they individual terms for each one?
And they're the same terms for each.
They're the same one for each term.
Yes.
Excellent. The court has one issue with this, which pertains to condition of pre-trial diversion 2, the first bullet point, which states this will require checking in with an officer and the time to be tracked. The issue here being that if they are unable to obtain police officers, they're very, very busy, what happens then? They may be prepared to go, and then afterwards they're unable to get an officer in order to be able to log their time. That is the one concern that I have with this, because the court has reviewed these in readiness.
Yes, Your Honor. Sorry, just give me just a second.
It's quite all right.
Blackstone.
Sorry, Your Honor. I'm just reviewing what I have.
Please do. I'm sorry, who is that in the well? Who's that behind council tables?
Jonathan Riley with the Department of Justice, Your Honor.
Are you noted on the docket at all?
No, she's asking for my help.
Right, okay. If you could go outside, please. The court will be imposing a term here, just so this is clear, because this might as well be resolved right now. In terms of the point of raising it with an officer, this court will not be making that a requirement. Photographs must be taken. This is to be done under good faith. The court sees no reason why that should be an onus upon them. There is no guarantee that they'd be able to get a police officer to verify they had indeed carried this out at the time. It's an incredibly onerous task on them, especially considering the only way they'd be able to get a hold of a police officer would be either through 311 or through committing a criminal offence in utilising 911 to make such a notice. There's no guarantee that an officer would be able to be there. As such, the court will not be insisting upon that. However, all photographs must be time-stamped, one at the start, one during, one at the end. Then afterwards, insofar as determining whether it's truthful, submission of which will be accompanying an affidavit to be signed by each defendant at the end of this pretrial diversion. Is that acceptable to all parties?
Yes, Your Honor.
Yes, Your Honor.
Defense counsel, excellent. Right, with that, the pretrial diversions will be set on the terms mentioned. There'll be a notice on the docket stating that they are indeed enforced. And then afterwards, the defendants shall be entitled to be removed from such terms of pretrial diversion at 23:59 Eastern on the 24th of March 2025. Is there any further matters for the court in respect of this matter?
Nothing from the state.
Nothing from the defense.
Thank you very much. Court is adjourned.
Your Honor, do you have a moment I might ask